Good afternoon, everybody. Welcome to today's webinar. What should your post-Brexit data protection planning include? Can I just ask you to type in the text box if you can hear me? Okay, that'd be very helpful. Perfect. Thank you, everybody. So we have roughly about half an hour. I know we've allocated, I think, 45 minutes for this webinar. I will talk through the slides. Thank you for everybody who posted questions on the registration form. I have them in front of me, so I will make sure that I cover those questions as part of today's session. If whilst I'm talking, you have any additional questions, if I can ask you to just hold on to them until we get to the question section, that would be fantastic. The webinar is being recorded, so if for any reason you need to drop out or the phone rings and you need to deal with work, not a problem. You'll get a copy of the recording. It will be available next week. So let's kick off. And I hope you don't mind, I've decided to put my video camera on so you can see just how excited I get when I talk about data protection. So let's go. So my name is Kellie Peters. I'm the co-founder of Databasix. I've been working in the field of data management and data protection for 20 years. I have experience working in both public and private sector. And for the last 7 years, I have run Databasix, an Oxfordshire-based consultancy company. And I'm basing my experience and my knowledge into these slides today. So I think it's useful to kind of put a position as to where we are today and where we need to get to come the 1st of January 2021, which feels like it's quite a long way away considering how long 2020 has felt for me anyway. So the UK has now left the European Union. This happened on the 31st of January this year. We are now in a period of withdrawal. So Brexit has happened. We are now in that withdrawal procedure, and it is our responsibility to make sure that we have everything in place, not just data protection, for our businesses come the 1st of January 2021. So EU law at the moment continues to apply in relation to the single market and customs union. And we are now following the withdrawal agreement, which was implemented into UK law. And it's stated there what it's referred to as. So the very first question I want to cover off right now is that EU GDPR still applies to us at this very moment. I will talk about how that will change from the 1st of January 2021, depending on the type of organisation you are in relation to the customers that you have and the transactions that you do. So what is the impact on UK data protection? So we are now outside of the EU and we are classed as a third country. Oops, sorry, I've gone back a slide. So we are considered a third country. We will be subject to strict data transfer rules as set out in the EU GDPR. So at the moment, obviously, we are still within that barrier within the EU. From the 1st of January, we will be viewed as a third country, very much like the US. And we will need to make sure that where we are processing information on behalf of EU residents, that we follow the rules set out in EU GDPR. We are, as part of the withdrawal agreement, looking for an adequacy agreement from the European Commission to demonstrate that we are a safe place for data to come from Europe to the UK. However, it has been, I've been looking at the news, there have been clear indications that that agreement may not happen by the 31st of December. A lot of it, I believe, is also as part of the discussion as to whether or not we leave the EU with a deal or a no deal. So my first statement to everybody on here is that we need to be prepared for a no deal situation and for the UK to be considered a third country. And I'll talk to you through about what you need to do in terms of preparing for that. So the ICO, and one of the questions I had was in relation to this particular question. So the UK's Information Commissioner's Office, who is responsible for implementing the GDPR in the UK, has stated that we will recognise any of the European Commission's decisions on adequacy. So that means that the countries that are listed in the first bullet point, where there is an adequacy agreement, we will continue to be able to transfer data to those countries because they have been able to demonstrate that they have an adequate level of data protection regime that allows us to feel that data is safe. We will also continue from the UK to the EU to send data onwards. Now, this for me is the time where previous slides before July, I would have talked about the EU-US Privacy Shield. For anyone that was around in July and was listening to data protection news in particular, you may have noted that there was a judgment that came down that essentially invalidated the EU-US Privacy Shield, which is why it's no longer on here. So that means any organisation that is US, where they have only ever been reliant on Privacy Shield, that means that they as a US company have registered with Privacy Shield in the US, that is no longer valid. They now need to demonstrate a different measure of compliance with the regulation. Now, that can be through standard contract clauses, and I have a slide a little bit later on where I'm going to talk about these in a little bit more detail, but for transfers from the EU and the UK to the US, you can use standard contract clauses. Now, the challenge with that is that if in the US there are laws in place such as the Cloud Act, that would mean that the US government could ask a cloud software supplier, such as a CRM system, for example, to have access to EU resident data. You cannot really rely on standard contract clauses because the government, the US legislation supersedes the contract clauses in place. Now, you might say, well, how do we actually continue to transfer data from the EU, UK to the US if we can't rely on Privacy Shield and standard contract clauses might not be viable? So my suggestion to you, and it's going to come on nicely to the slide where I talk about data mapping, is identify all of your US-based systems that you have in place and have a conversation with those companies and say, when we are transferring data, so we are entering clients' information or staff information into the online system, how are you going to guarantee that if the US government asks for data, that you will not share or provide access to European resident data? And see what they come back with. I am still waiting, as I think a lot of people, waiting for the ICO to give out stronger guidelines on this, but I would do a little bit of due diligence at the moment. I'd be honest, I think it's a little impractical to say stop using US-based systems, because I think that will cause quite a lot of distress to individuals. The other thing I would make a point about transfers is obviously any trade deals that the UK is going to make with the US is likely to include a conversation about data transfers. So we may end up having a very specific agreement between the UK and the US about how data can be transferred. However, that deal hasn't been signed off yet, so watch this space. So what the very first step in any kind of plan that you should have in terms of Brexit and making sure that you are compliant is to continue to comply. So in the UK, we do have the UK Data Protection Act. So there are two scenarios that I have set down on this slide. If you are a UK company and you have UK personal data and you're not processing any European resident data, all of your systems are in the UK. So you're using, say, a cloud-based accounting package, or you have a HR system, or you're using a newsletter tool, and the servers are in the UK and there is no data that goes outside of the UK, then on the 1st of January, what applies to you is the Data Protection Act of 2018 and the UK version of the GDPR, which will be brought into law by the 1st of January. Now, I imagine that's going to be not a large number of companies. So if you are a UK-based business with EU residents, personal data, now this may be your staff, this may be your clients, this may be suppliers, you will be required to adhere to 3 data protection regimes. It will be the UK Data Protection Act, it will be the UK version of the GDPR, and the European version of the GDPR. Now, at the moment, all of those are going to be relatively aligned. However, because we are now leaving Europe, our data protection regulations may change depending on some of the trade deals that we may be wishing to make. So first point, comply, understand as well where your data and who your customers are, which I imagine you're all very comfortable with. Now, this step 2 may be something that you've also done, but I would ask you to revisit this. So map your data flows. So where does data come into and out of your business at this moment in time? And think of the flow of data, both from a personal data perspective, and personal data is anything that identifies us, including photos, IP addresses, device ID, and that of special categories of data, which is health information, race, ethnicity, biometric information, for example, and map where data goes from the UK to the European Economic Area, that includes Norway and Liechtenstein. Then map any data that comes from the European Economic Area to you. So do you have European customers or clients that send you data? Or do you have an office in Europe where there is data that is regularly transferred from Europe to the UK? And then think about UK to the rest of the world. So that's what you want to be mapping. And this would involve you looking at the systems that you're using and understanding where those systems are based. So when you look at your register of processing activities, or you might have called it an information asset register or your data mapping tool, you want to be listing the physical locations of where that data is going to be stored, because it's important when you're looking at the mapping of that data. Because at that point in time, you'll be able to know whether or not it's covered by the European data protection law, whether or not it's covered by a adequacy agreement that the UK is acknowledging is valid because it's what the EU use, or whether or not you're going to have to rely on introducing standard contract clauses. So data out of the UK to Europe can flow freely. The challenge is going to be where you are receiving data from the EU to the UK, because if you recall, I said that we are now going to be a third country. So what you may start to receive, if you haven't already, is some of your European clients asking you to demonstrate how you are going to comply with data protection. Now, they may do that through contract clauses. So some of the things, which is what step 3 is about. So you've mapped your data. So you know the flow of data into and out of your company. Now you need to be thinking about the necessary safeguards that you're going to put in place in contract clauses to be able to put your hand up and say this is good. Now, to be perfectly fair, if you're already following data protection legislation in this country, there should be no reason why you can't adequately demonstrate your compliance to your European customers, because nothing's going to have changed from the 31st of December to the 1st of January, other than the fact there will have to be a contract between those parties. So that contract should include the technical and organizational security measures. So things like backup, what type of antivirus, how do you keep the data secure? How do you prevent external threats getting access to the system? What is the clear purposes that you're processing that data for? So are you a UK-based payroll provider where you are acting as a processor on behalf of European clients? Therefore, there'll be quite clear purposes for why you're processing that data. Clearly set out who your UK data protection lead is, whether it be a data protection officer or a data protection lead. You may add statements such as you will comply with audits on behalf of any of your European clients so they can check how you are actually demonstrating. So how do you comply with the accountability element of the GDPR? And you want to make sure that they're signed by both parties. So don't just assume that when a European client sends you the contract that you have to sign it. Make sure that you're happy with what is being asked of you and that you can actually fulfill those clauses. So one of the questions I had was, will European standard contract clauses still apply? And the answer to that is absolutely yes. So the model clauses that the European Commission has approved are going to be recognised by the UK Information Commissioner's Office. So if those are clauses that you're already using, there are no changes to those at this moment in time. Now, what also changes on the 1st of January is that the UK will no longer be on the European Data Protection Board, and we will no longer be part of the one-stop shop. So that means at the moment, where you've seen a European Data Protection Authority, so if you look at the likes of the Irish Data Protection Authority that has taken the action on behalf of Facebook, for example, they are acting on behalf of European data protection supervisory authorities as one head organisation. So they are not individual supervisory authorities taking action. It is one. Now, Brexit takes the UK out of that. So how does it affect you? If you are a UK company and you have your head office is in the UK, and your supervisory authority at the moment is the UK's Information Commissioner's Office, and you have European offices, then you will need to select an appropriate supervisory authority so you can comply with the EU GDPR. So you'll no longer be able to purely be reliant on the ICO. So I've given an example here. If you have a UK and a French office, you will need to be registered with the French Data Protection Supervisory Authority, CNIL, and they will then, if there are any breaches by your organisation, you would report it to them, and they would then act on behalf of any other European member state. Now, you, as the UK company, will still need to be registered with the Data Protection Act of 2018 because that is a requirement of UK law, but you will also need to be registered with a European supervisory authority. So again, look at your offices. Where does it make most sense? So for example, if you have a head office in Italy or in Germany and you have a UK office, then register with where the majority of your processing takes place in Europe. The other question is, do you need to appoint a European representative? So this is where you are a UK organisation. You do not have any European offices at all. You are only based in the UK. However, you do offer goods and services to individuals within the European Economic Area, or you monitor the behaviour of those individuals. Now, if that is the case, you will need to consider whether or not you need to appoint a European representative. Now, the question is, and you just bear with me, I just need to find my additional notes, is that there are some exceptions to this. So if your processing is only occasional, then you do not need to appoint a European representative. If the processing that you are doing is low risk, for example, it might only be contact details and email address, for example, and it doesn't involve any kind of special categories of data, then you do not need to appoint a European representative. If you are a UK company with European offices, then you don't need to appoint a European representative. However, if your processing is more than occasional, so for example, you are a UK company and you offer services to a large number of clients in Germany and Sweden, for example, then what you'll need to do is you will need to appoint someone in country to act on your behalf to interact with the supervisory authority in that country. That will have to be a contract between you and them, because not only can that European representative be fined for non-compliance on your behalf, but it can also come back to you. So assess whether or not you need to appoint an EU representative. So what you also need to be thinking about, and I'm sure that you already are as you're listening to me talk about this, is that your data protection policies, your privacy notices are going to have to be updated. So your privacy policies on your website, if you're a UK company, can no longer refer to Privacy Shield because it's invalidated. You'll need to update your privacy policies if you are if they only talk about UK, or if they only refer to the GDPR, they now need to refer to both the UK GDPR, the UK Data Protection Act, and the European GDPR if you have European clients. Your data protection policies will have to be updated, because if you have a personal data breach, they'll have to be very clear about who is your supervisory authority. So at the moment, your privacy policy may say, please send all complaints to the UK's ICO. Now, if you are a European organisation and the ICO are no longer going to be your supervisory authority, you'll need to be able to identify where complaints can be made to. You will also need to be reviewing, as I've already discussed, the international data transfers. So where you are transferring data outside of Europe, and you're maybe going to the US, for example, you'll want to be stating in how you're going to be responsible for those data transfers. So are you going to be relying now on standard contract clauses? It may also be worth just checking where you are from a risk perspective. So if you have a data protection impact assessment where you've assessed the risk of a particular software system or a processing activity, you may wish to review that in light of the relationship that we are now going to have as a third country with Europe and stuff. So are there now greater risks to individuals because of that? And if they are, what are the contingency measures that you are going to put in place to address that? Then I think the other important thing is, and this is where I see a lot of organisations not doing so well, is that they will update their policies and their procedures, but they will not communicate this to their staff about what's changed. Now, it may be that all that is changing is that you're going to reflect the fact that you are going to be using changing reference to UK data protection rather than just having EU GDPR. Or it may be because of what is going on with the Schrems II decision, you may now be asking your staff that before they use US systems, can they please check to make sure how that US company is going to protect you in relation to that data transfer. So make sure your staff are aware of how this Brexit is impacting on your compliance with data protection. Now, it may just be briefing sessions that you might want to do. It might just be regular email communications, or you may feel that some staff may need more specific types of training. But please don't forget to explain to staff how it's changed for you. Oh, okay. Oh, wow. I didn't even realise it was 25 past already. So really, now's the time for you to ask some questions of me. So please do use the chat box. I'm just checking the list of questions that came up to me in preparation for this to make sure I've covered all of them. But are there any particular questions that anyone has? Where are people? Okay. So we've got a question about Dropbox. So what I would suggest is that you the paid for version of Dropbox, I believe, is based in Ireland and stuff. So obviously, the what you'll just need to check with Dropbox is how are they protecting your data? I believe it will be through contract clauses, to be honest. But maybe it's worth just a quick check-in to say, look, now that the UK is a third country, are there any other additional measures that you're going to put in place in storing our data? But other than doing that kind of due diligence, I don't think you have to do anything else. If you're using the free version, however, the data may be stored in the US, and then it may be subject to the US government having access to the data. So the question would then be, the data that you're storing in Dropbox, what's the level of sensitivity that it is, and would you want some reassurances from Dropbox that they are going to protect the government from seeing that data? But that'll be the same questions I'd want you to ask for any US provider, to be honest. Can I ask, has anybody started mapping this particular work? Have you come across any challenges with like the Schrems II decision? Did it have a big impact on you? Has anyone made decisions to stop using systems in the US because of Schrems, or are you seeing your clients asking you for to sign contracts? So I can see some people typing questions. That's brilliant. So I'm going to let those questions continue to be typed. Yes, so that's a really good question. So post-Brexit, is it possible to use derogations for occasional EU customers, mostly the UK, just the odd one or two? So yes, there are Article 49 of the GDPR does talk about derogations that you can rely upon. So you could, for example, rely on explicit consent for the data transfer for the individual. You could rely on actually for you to be able to fulfill the contract that you have with the customer, that's part of the data transfer. So yes, you don't have to rely on standard contract clauses if you do have a specific derogation, but it should only be for occasional use. If it's going to be regular, then you'll need to look at something a little bit more robust for your processing. Yeah, there's a really good comment that's just been made, in that it is difficult for organisations to make meaningful risk assessments on the US surveillance law and whether standard contract clauses would be valid. Like you, I am waiting for clearer guidance from the Information Commissioner's Office. I think, to be honest, it is incredibly unrealistic to ask people to suddenly just stop using US systems. It's just not going to happen. So I think in that instance, it's the standard contract clauses are the only means in which that data transfer can happen. Unless, of course, the UK and the US come to some kind of trade agreement that allows that flow of data to happen freely. One would hope between now and the end of December that that information is given to us in a little bit of clarity so we can digest it. However, I would just say on your mapping tools, note that you are relying on standard contract clauses and just keep an eye on it, to be fair. Will we need data sharing agreements to share data with our acquisition in Australia? So if you are, if they're going to be part of the same group, for example, you could consider binding corporate rules. I mean, to be fair, that's quite a challenging task, but it does mean that you can, across a group of organisations that sit within the same entity, you can share data as long as you have a common framework of data protection. If binding corporate rules, and they would have to be agreed by a supervisory authority, you could have an agreement in terms of that sharing, of how you're going to manage that sharing, how you're going to ensure that you've got the right technical measures in place, making sure that you've got you do regular audits of that, making sure that only those people that should have access do have access to the data, for example. So it can all be part of an agreement between the two companies for that transfer. So I can see I've still got a few people type in questions, so please continue to do so. So the question is, would it be the same for a joint venture in another country outside of the UK and the EEA? So where there isn't an adequacy agreement with that non-EEA country, there will need, and you're not necessarily confident about how that country manages data protection, then you would definitely want some kind of contract between you and the joint venture, just to be very clear about the sharing of the information. I mean, if you're both data controllers, then an information sharing agreement would make sense, because it allows you to set out the purpose of the data sharing, how regular the data sharing is going to happen, the technical measures that you would be putting in place to protect the data and limit who has access to that data. So I imagine you're both data controllers, so a data sharing agreement would make sense, and then that's binding between the two companies and make sure it's signed. I wonder, are there any other questions that we have at the moment? I'm loving the fact that there are so many questions. I would also suggest that everyone continue to keep an eye on the ICO website. I'll be perfectly honest, I don't think they have been as regular in giving updates as I would like, but do keep an eye out. And if anything changes, I will most definitely do an update webinar. So if there are any more questions, please do type in the text box. If you do think that you need any external help, my 60-second pitch is obviously, as Databasix, we can support you in data mapping if you haven't done that already. If you need support in terms of the types of questions that you'd want to ask your US vendors to do due diligence, we could help. If you want your policies and your procedures reviewed, or if it's just that you need a phone call to talk to someone about your rationale in terms of what you're doing from a data protection perspective, we can help you with that. We have a variety of tools that are available to you. We have a weekly podcast. This week we talked about the Track and Trace app that's just been launched in the UK. We have a suite of online facilitated training courses that you might be interested in, or you might just simply want to continue to receive information about these webinars. They're all of our social details should you be interested. So with that, it's really for me to say thank you very much for everybody for listening to me talk for just over half an hour. If you would like a follow-up, let me know. I know there was a couple that said yes on the registration form. Do contact me. But if not, I hope that you all have a very fabulous rest of today. Keep warm for anyone in the UK that might be freezing. Anyone that's outside of the UK that's somewhere warmer. I'm very jealous. Have a great day, and I hope to see you online again at one of our future webinars. So thank you very much.